and let Alyssa take it away. Thank you so much.
All right, thank you to you both and welcome everyone again. Today we're going to be discussing what housing court looks like today, now that many of the pandemic era protections have expired. So unfortunately, this is the first time since probably March 2020 that many of our clients, your patients, are at risk of being evicted. Obviously, this training is not meant to make you into housing attorneys, but we do hope that this overview will give you the information you need to spot when a patient may be experiencing housing instability, and resources to be able to point them in the right direction. So as has already been explained, we are in a webinar mode today. So if you have questions, you can put them in the Q&A and Simone will be answering them throughout the presentation. And then we'll also have time at the end of the presentation to answer some of the most common questions, and to get any last issues squared away. And if they haven't already gotten to you, these slides will be made available. So don't worry about that. A little bit of information about who we are. Simone and I both work at LegalHealth. LegalHealth is the largest medical legal partnership in the country, and we currently have 35 hospital sites in New York. So hopefully we are in one of your hospital sites. The goals of today's training are to understand the current state of housing court in New York City, to review the basics of eviction proceedings and existing legal protections for tenants, to recognize rental assistance programs in place for at-risk tenants, and to learn how tenants can exercise their right to a safe and habitable home. Go to the next slide. There we go. So as I'm sure all of you know, housing is a social determinant of health, and eviction in particular can cause toxic stress and destabilize entire families, forcing people to move to substandard housing or even enter shelter. Obviously, poor quality housing can contribute to poor health conditions and poor childhood development. And people who have difficulty maintaining stable housing also have difficulty accessing regular care. And of course, if a person does become homeless and enter shelter or start living on the street, that the health implications can be absolutely devastating. Thankfully, we live in New York City, and New York, at least compared to other states, does have fairly strong protections available to tenants, even after many of the pandemic era protections have expired. The main one is that people cannot just be thrown out, right? If you've been living in an apartment or in a home for more than 30 days, the only way that you can be forced to leave is if your landlord gets a final judgment and order of eviction from the court, and if they get the help of a city marshal to evict you. It doesn't matter a tenant's behavior or alleged behavior. It doesn't matter if they haven't paid rent ever. They cannot be locked out. And if they are locked out, we can talk about solutions later on in today's training. But if you take nothing else away from this training, just remember that tenants really should not self-evict. Eviction proceedings, though technically summary proceedings, do take a very long time to get through the court system. And there is a lot an attorney can do to help prevent an eviction, or at least delay an eviction so that a person or a family can move with dignity. But there's very, very little an attorney can do if a person chooses to leave on their own. So make sure that tenants know they don't need to leave until they are evicted by a city marshal. I think that Simone has been doing these trainings throughout the pandemic. So you probably heard a lot of phrases like the Tenant Safe Harbor Act, and you helped patients fill out hardship declarations and ERAP applications and all sorts of things. Unfortunately, at this point, many of those pandemic era protections have expired. Courts are moving in a very similar way that they did prior to COVID-19. New and old cases are moving through the system. So if tenants are now getting court papers, or if they have court papers from prior to the pandemic or any time during the pandemic, they should be aware that those cases are likely going to move forward and they should be paying attention. All appearances are now in person, And anytime that a tenant needs to, for example, submit an answer or an order to show cause, they need to do that in person. Also, unlike during the pandemic, tenants are now being screened for a free attorney when they're at their first court appearance. There were times during the pandemic, as I'm sure you know, that tenants were getting phone calls from attorneys, or they were able to make appointments for legal service providers prior to their court date. That isn't happening anymore. They really need to know that they can go to court and at that first court date ask to be connected to an attorney. And for tenants who just don't really, cases were stayed, cases were paused, people don't really know when they're supposed to go back to court, they should know that they will receive a postcard with an upcoming court date. And that's how they'll know that the case is moving forward. I know that a lot of this is probably going to be information you already know, but since it has been 2-3 years since housing court was normal, we figured we would do a quick overview of eviction proceedings. To start us off with a very common case example, we have Mary here. Mary comes to in a panic. She says she got an eviction notice on her door last night and doesn't know what to do. I guess our question is Mary at risk of eviction in the next 2 weeks? Is she at imminent risk of eviction? You're welcome to put your questions or comments in the chat. I see a lot of no's, which is great, or not yet. The truth is, it kind of depends, right? It depends on what kind of court papers she's received and what stage of the proceeding she's currently in. So maybe we can go through each of these different types of eviction notices here. So the first one, and maybe we can scroll down to see like the picture of it, is a predicate notice. So a predicate notice is, I would say, the most common one that a person might come to you with. They'll say, I got this notice and it says I have to leave in 14 days or I have to leave in 60 days. And I don't know where I'm going to go. Like I said, as I'm sure you know, this is not an eviction notice, right? This is a predicate notice just warning them that a case may be coming relatively soon. If they're behind on rent or the landlord thinks that they're behind on rent, they might get a 14-day rent demand. If their lease is up or their landlord doesn't want to renew their lease, or perhaps their landlord is alleging that they breached some provision of their lease, they'll get a 10-day notice to quit or a 30, 60, 90-day termination notice. Again, these are not eviction notices. These are just notices that have a date by which the tenant has to pay the rent or they have to leave. And if they don't, then they're being warned that they will face summary proceedings, basically an eviction case in housing court. If they don't leave, so if the 60 days expires and they haven't been able to find somewhere else to move, they'll get a notice of petition and petition. These are papers that look very much like court papers, right? They'll have the name of the housing court in the top left-hand corner. There will be an index number. Their name should be on it, and their landlord's name will be on it as well. It'll also tell you whether or not it's a non-payment case, or a case about rent, or a holdover case, a case about something else. And it'll provide a date on which the tenant has to either answer or go to court. And finally, we have a real marshal's eviction notice. So these are much, much less common, but tenants do receive them. And now that the eviction moratorium has expired and many of the protections have expired, we're seeing more and more patients coming to us with these marshal's notices. The marshal's notice means that the housing court case is over and the tenant has 14 days to either leave or they can go to housing court and ask for more time. If they do neither of those things, if they don't leave, if they don't ask for more time, a marshal can come and force them to leave the home. So now we're back to Mary. So is she at risk of eviction? It depends, right? It depends on what she found on her door. If what she found is a 14-day notice or a termination notice, you can just tell her, prepare for court. You don't need to leave at this point. If you're behind on rent, you can go apply for some rental subsidies, but there's nothing more to really be done. If it is a petition, you can instruct her to go to court and file an answer and ask for an attorney in court. And if it's a marshal's notice, then she should go to housing court immediately and ask for more time. So it's really important to know, even if you're not a housing attorney, it's important to know kind of what stage of the proceeding your client or your patient is in, so that you can reassure them or warn them that they need to take action immediately. You don't need to help them do that, but at least give them the instructions of kind of like the next step for their case. So once they've received a petition, so once they got actual court papers, they should file an answer. If it's a non-payment case, they have to file an answer within 10 days. If it's a holdover case, they don't necessarily need to file an answer immediately, but to avoid confusion, it might be a good idea to just across the board instruct tenants to go to housing court and file an answer. Unfortunately, answers now must be done in person. So they have to go to the clerk's office in their local housing court and file an answer in person. If it's impossible for them to do that because of a health condition or a disability, they can request a reasonable accommodation. Different courts are doing it differently, but usually it involves being sent basically like a copy of an answer to fill out from your home. Tenants do not and will not probably have an attorney when they file an initial answer. They should file an answer on their own, and then on the first court date, which they'll receive when they file an answer, on the first court date, they should ask to be referred to an attorney. They don't need to worry about doing the answer wrong. The attorney can fix it. They just need to file an answer so that they can get that first court date and so that they don't default. If they don't file an answer, it's considered a default and they can be evicted basically after the 10 days is up. For requesting a reasonable accommodation, at least in New York City Housing Court, there is a pilot program for an online reasonable accommodation request form. The link should be linked here, but it's also very easy to Google. If they're in New York City Housing Court, you can also email the chief clerk with the ADA request. Her email is right here. If you want to help your client or your patient, it's not required, but it may be useful for them to have basically like a doctor's note or some kind of letter from a healthcare professional indicating why they need a reasonable accommodation, usually why they're not able to make it in person to court. Okay. Now just to review the types of cases that might come up. First, non-payment cases. These make up like 85% of all cases in housing court. These are usually pretty simple. It's a dispute over alleged unpaid rent. Like I said before, a tenant really needs to file an answer within 10 days. That's the only way that they're going to get a court date. If they don't file an answer within 10 days, there won't be a court date and they won't be able to present any of their defenses, which they may have, right? They may have defenses about the apartment being illegal, the rent amount being illegal. Something we see a lot is repairs issues or harassment by their landlord. And perhaps they've already paid rent or a program has already paid rent and it's all just a misunderstanding. But like I said, they won't be able to enforce any of those rights unless they file an answer and go to court. These often are pretty easy to resolve without a trial. And if tenants don't have that money saved and they do owe rent, they can file an application for a one-shot deal or a housing subsidy like FEPS, City FEPS, HASA, that kind of thing. So we have our next case example, Lucia. Lucia is an undocumented mother of 3 and rents an apartment for $1,500 a month. She works several jobs to support her family, but her hours were cut during the pandemic, and she's 6 months behind on her rent. She came home and found court papers taped to her front door. She has no idea what to do. She doesn't have the $9,000 saved up and is worried that her family is going to be evicted. So how can you help her? Right, so basically the same thing we've been saying this whole time, right? Review her paperwork, identify which stage of the proceeding she's in. If she got a petition, if she got actual court papers, instruct her to go to housing court and file an answer. If she thinks she owes rent, she can bring that petition to HRA and apply for a one-shot deal or a housing subsidy if she's eligible for one. And when she is in court, you should instruct her to ask for an attorney, a free attorney. She may not need one if the case is easy to resolve, but if she has defenses that she wants to pursue, it might help to have an attorney on her side. All right, the other type of case is basically everything that's not a non-payment case. It's called a holdover case. There are multiple kinds. The most common is what's called a no grounds holdover. Basically, if a person doesn't live in regulated housing, their landlord isn't required to give them a renewal lease. If their lease has expired or the original leaseholder has left or died, landlords will often bring this kind of no grounds holdover. There are a smaller subset of cases called good cause holdovers. Usually this is where a landlord is alleging that a tenant has breached some lease provision or is causing a nuisance. So for instance, causing a lot of noise at night, or they have a dog and their lease prohibits pets, something like that. In these cases, a tenant will receive a termination notice, the length of which kind of depends on how long they've lived in the apartment. Or they'll get a 10-day notice to quit, usually if they're alleged to be committing some kind of nuisance. Unlike with a non-payment case, the petition that they receive will have a court date. So they don't have to go file an answer if they don't want to. They can answer on that first court date. The court date will be on the petition. Holdovers tend to be more legally complex. They're more likely to go to trial. These are the types of cases that we really encourage people to, really try and get an attorney to help them. So if that means, if they can't get an attorney the first time, continue asking the judge to assign them one, because they can be really helpful in either preventing an eviction, winning at trial, or at the very least negotiating some kind of settlement so that they have plenty of time to relocate with their family. For this, we can use Maya and Santiago. They've lived in the second floor of their 2-family home for 5 years. A new owner has bought the building and hasn't renewed their lease. Santiago comes to you with a notice he found on his door. He's frantic, thinks he needs to leave immediately, and doesn't know where his family is going to go. So, do we think that Santiago needs to leave immediately? Hopefully this is pretty clear. No, exactly. He does not need to leave immediately. He probably got a 90-day termination notice. He has 3 months to move out, or, he might be subject to an eviction proceeding. So just like before, review his paperwork, identify which stage of the proceeding he's in. If it's a termination notice, remind him he doesn't need to move out right away. He can go to housing court. If it's a petition, he should go to housing court on that day and try and get an attorney who can help him through the process, and just make sure that he's, of course, asking to be assigned to that attorney. All right, so those are the very basics. And those are the same as they were right before COVID started. Housing court is pretty much back to the way it was. But there is this kind of wrinkle. So there's this huge backlog of cases that have been put on pause for months, if not years. A lot of these cases have come back to court and then been put on, have been stayed again, or have kind of been, in this ether of cases that aren't moving. It's really important that people know that just because a case hasn't been moving forward for quite some time doesn't mean that the case is going away. A lot of these cases were put on pause because of hardship declarations or because of ERAP applications, and they're now being recalendared. There are other cases that don't even need to be recalendared. Landlords can basically take action regardless, without giving the tenant further notice. If a judgment or warrant was already issued, so if before COVID or during COVID, the case was already finished, right? And they already got a judgment and they already got a warrant. The landlord no longer needs to give the tenant any notice. They don't need to bring the tenant back to court. They can just act on that old judgment or warrant. So people should know that they are at risk. They might want to take some action, maybe getting a one-shot deal, or at the very least, wait for an eviction notice so that they can go to court to ask for more time. If a tenant defaulted, like if they never even filed an answer, they also might not be served with any further notices, any further court papers. The landlord can technically evict them without taking further action. So if there was already a judgment or warrant, or the tenant just never went to court, they need to know that they could be evicted and should take some kind of action. In all other cases, tenants are going to receive a postcard with an upcoming court date. And if it's not totally clear to a tenant, what category they fall into, what bucket they fall into, they should call housing court and ask, or get referred to an attorney who can help them, sort through the papers. All right, and just as an example of this, we can see Amir here. Amir is a father of two. He works full-time in construction. He fell behind in rent in October 2019, and he was served with papers, went to court in February. He agreed to pay the rent by the end of March. Of course, March 20th hit. He never heard anything else about the case. He's now worried that he agreed to pay so long ago and his family can be evicted any day. Should Amir be worried? Yes, I'm seeing a few yeses. Yes, he should. Unfortunately, even though he agreed to pay all that time ago, depending on what is in that stipulation that he signed, that settlement that he signed, he could be at risk of eviction. So just like before, you should review his paperwork and identify if the document that he signed included a judgment or a warrant. It would say it on the stipulation. It would use that language. You should determine, if he owes rent, how much he owes, and see if he could apply for a one-shot deal or a rental subsidy. If he owes rent and he pays all the rent, he probably wouldn't be evicted, right? If there is a judgment or warrant, remind him that he could be evicted without further notice, and that if he does get an eviction notice, he needs to pay attention to it and immediately go to housing court and ask for more time. And of course, you can refer him to legal services for further help. All right, so spent a lot of time talking about all the protections that no longer exist, but thankfully there are many protections still available to tenants in housing court. So we'll go through a few of them right now, some of the bigger ones. First is right to counsel, or technically it's called universal access. This is in New York City only, but it should be expanded to other parts of the state. Lucia, Santiago, and Amir all have the right to an attorney in housing court based on this universal access program. Universal access was started back in 2017 for low-income tenants in certain zip codes. During the pandemic, the City Council expanded universal access to all New York City zip codes. So now all tenants in all zip codes of New York have the right to be screened to determine if they're eligible for free attorney in housing court. They're supposed to be screened by people from HRA who are in housing court every day. And usually it's done on the first court date. In practice, not all tenants are getting connected to counsel, even if they're eligible, due to lack of funding and just a lack of housing attorneys. But in theory, they do have this right to a free attorney in housing court, and they should try to enforce that right by continuing to ask for a housing attorney when they're in court. So even if they don't get one on that first try, they can continue to ask, and the judge really should be making efforts to get them connected to counsel. One protection that actually does still exists is the Emergency Rental Assistance Program. I'm sure a lot of you have done many of these ERAP applications. ERAP is a program that was created in connection with some federal funding and also state funding later on for people to cover 12 months of rent arrears, 3 months of future rent, and then some utilities as well for people who fell behind during COVID. The application did finally close as of January 2023. So they are not accepting any new applications, but pending applications are still being considered. So if you have patients or clients who have already applied, have already submitted all of their documents and still haven't gotten an answer, you can tell them that just because the portal closed doesn't mean that they have been denied. They very well may get the funds that they need. ERAP also comes with additional protections. So some cases still are paused because of an ERAP application. People who apply for ERAP, their case is put on pause. It's ERAP stayed. And for landlords who accept ERAP, they're not allowed to evict their tenants in no grounds holdover. So for an end of lease holdover for a year. So there are many cases that are still put on pause because of these ERAP applications. But as more applications are processed, those cases are moving forward. And unfortunately, we can no longer advise tenants who are facing eviction to just apply for ERAP and kind of wait it out because the portal has closed. There's also this protection that was never really used prior to COVID, but in 2019, the summer of 2019, the state legislature passed the HSTPA, which was this huge housing bill that had all of these tenant protections that quickly became irrelevant because COVID happened and COVID protections kind of took over. But a main part of the HSTPA was this extra protection for tenants in housing court, giving judges discretion to provide additional time to move up to 12 months, even after a tenant lost at trial, even if they defaulted on a stipulation. So essentially, before 2019, judges could give up to 6 months, and there were all these rules about it. And after the HSTPA passed in 2019, judges can now give up to 12 months to move out. This is why tenants should not self-evict, because even if they get through the whole process, which takes months, they can still ask for additional time, and that time could be given at the judge's discretion. Judges are more likely to use their discretion if a tenant can show that they're making attempts to move out, or if they can show, quote unquote, a good reason for why they're having difficulty moving, which, very often is the case for elderly tenants or tenants with serious medical conditions. And finally, tenants can be referred to their local home base to be screened for a variety of rental assistance programs, including FEPS, city FEPS, HASA, a shelter allowance, and DRE and SCREE, the rent freeze programs here in New York City. If people have specific questions about these programs, we're happy to answer them. But for your purposes, you can just know that a person might be eligible if they are on cash assistance, if they're receiving cash assistance from HRA, or if they have a shelter history, especially if they have a recent shelter history or are in shelter now. I think I saw some people from Homebase in the chat. I know that Homebase is really, really overworked these days, and so it can be really difficult for tenants to get an appointment. But you should have tenants should be able to call and make an appointment, even if it's not, in the next couple of weeks. They'll eventually be seen. All right. Now we're going to shift gears a little bit. We will have another training in May, I think later on this spring, about getting tenants help for repairing poor conditions in their home and other kinds of tenant-initiated actions. But because it is something that comes up so frequently, we wanted to make sure we touched on it here too. So in New York, all tenants And I say tenants in a very broad way. I really mean all occupants. Anybody who lives in an apartment or a home has the right to habitable housing under New York state and city law. It doesn't matter the type of housing that they live in. It doesn't matter their immigration status. Frankly, it doesn't matter if they're paying rent or have ever paid rent. Everyone has the right to safe housing, and every owner of housing has an obligation to provide safe, habitable housing. There are many, many ways that landlords can violate this right? There's millions of housing code violations. A big one that you see, though, is heat violations. So from October 1st to May 31st, we are technically in New York City's heat season. This means that landlords have to keep their apartments at certain temperatures throughout the day and the night, depending on the temperature outside. It's a very difficult right to enforce, in part because often it's kind of subjective, right? It's not like you can come and you can see that a sink is broken. When they get to court and they have to explain, what the temperature is, it can be very difficult. But there are resources to help tenants. They can get connected to a place called HeatSeek, which can help them enforce their rights to heat in their home. They can also continue to call HPD. HPD can send inspectors to the home. Probably they're going to have a hard time getting a violation for heat placed on the first visit, just based on the temperature outside, especially these days when it is so warm during the day. But if they continue to call 311 and get HPD inspections, hopefully eventually a violation will be placed. Now, once they know that there are violations in their apartment, how can they enforce their right to this, their right to habitable housing? First, they should notify their landlord of the issue, ideally in writing, and keep a record of that. They can do this over text message if they, have that kind of relationship with their landlord. They can send a letter. There is a website, we'll link it later on, called Just Fix, which allows tenants to send a certified letter to their landlord explaining exactly which conditions need to be fixed. And that way they can prove that they received it. If nothing happens, they can call 311, or if they live in NYCHA, the customer call center, and make a complaint for the issue. HPD will come to visit and they'll issue violations and give the landlord some period of time to fix the problem. Tenants really, if they're going through this step, they really need to give access when the landlord comes to fix it. If they don't, they could be at risk of eviction. So it is important that if they're going to go down this road, that they're willing to give access to their landlord. And if none of these things work, we can talk in a minute about court actions for repairs. So how can you help the patients that are coming to you? Just make sure to educate the patient on the link between their housing conditions and their health conditions. Ask about steps that they've already taken. Maybe they haven't done any of these things yet because they've been too nervous to. Maybe they've done all of these things, and what they really need to do is bring a case in housing court. We also want to make sure that people know that they can call 311, they can go to housing court regardless of their immigration status. They have this right regardless of their immigration status, and HPD also doesn't ask about immigration status when they do inspections. And finally, it can be helpful for patients to get a medical letter explaining why they need, in particular, why they need these conditions to be resolved quickly. All right, so when patients come to us, our first question is always, 1, did you tell the landlord about these conditions in your apartment? And 2, if they have and nothing was done, have you called 311? If they are trying to get repairs done in their home and the landlord is not being cooperative, the best step is to get an HPD inspection done so that HPD can issue violations. Once the violations are issued by HPD, they're going to have a very, very easy time in housing court getting an order requiring their landlord to correct the conditions. If they don't, call 311. If they don't have violations placed, they can still go to housing court, but they're going to have a much harder time proving it, proving the conditions exist. They're going to have to go through a whole trial, giving testimony and photographs. It's really, really much easier if they can just get the violations placed by HPD. If they have the violations placed, they can go to their local housing court, go to the clerk's office and file an HP case, a housing preservation case. They should follow all the service requirements written by the judge. They should grant access to HPD for an inspection or to their landlord for repairs. And they should go to court on their court date and tell the judge that they need an order to correct. Finally, and we just put this in because people are worried about it a lot. If a landlord were ever going to retaliate against their client by locking them out of the apartment, the tenant does have the right to go to housing court and get an order requiring the landlord to let them back in. Usually, if a person is illegally locked out, the police are aware that this is a crime and will advise the landlord to let them back in. If it doesn't work though, or if they're too worried about contacting the police, they can immediately file a case in housing court and they'll push that along pretty quickly. Just make sure to show up to all court appointments. The most common reason to lose this kind of case is to just not go to court, right? Okay, and finally, we just figured we would include some, useful links. Homebase is a great place to send tenants who have questions about their eligibility for housing benefits. Homebase, they have contracts, or HRA has contracts with different nonprofits in the city who can help people kind of navigate that process. Housing Court Answers is a great resource for tenants who have questions about housing court, who are at risk of eviction or have received eviction papers and aren't sure what they mean. Housing Court Answers has a hotline and are usually very helpful. And for people who need repairs or want to learn more about their landlord, they can go to justfix.org. This is a good resource for a lot of things. You can learn about your rent. You can request repairs from your landlord. And they also have instructions on how to sue your landlord in housing court. All right, so I know that was a ton of information. I know that Simone has been answering questions in the chat, but maybe we can take this time to put any of your last questions in there and answer some of the most common ones. I don't know if that's the best way of going.
Yeah.
Okay.
Alyssa, that was amazing and so much great information in 45 minutes. I'm gonna tell you some of the most really interesting questions we had, which are people start putting Q&A questions in the Q&A. We'll definitely answer them, but I saw some really great kind of in-depth questions about housing court. I'm going to start with one where someone was asking, can a landlord discriminate against someone for mental health issues and try to evict them based on maybe some of their behavior? Can you talk a little bit about your experience with those types of cases?
Yeah, that's a great question. And it's something that actually does come up pretty frequently. People who are, if people have a disability, they do have the right to reasonable accommodations from their landlord, and they also cannot be evicted due to their disability. Right. So if a person is having a hard time in their housing and is not currently being evicted, you can help that person request a reasonable accommodation. This could be a lot of things. Some people need extra reminders to pay their rent. Some people need some extra support in their apartment, perhaps like help bringing down the trash or something like that. Those are reasonable accommodations that people have a right to in their apartment. If people are being evicted because of behavior related to a mental health disability, they can use their mental health disability as a defense in housing court. So it's not like an automatic win. You're going to have to prove it just as any other defense, and as you would have to with any other defense, but it is available to people. In those cases, I would really encourage them to be able to get an attorney, because it is not going to be easy to manage that on their own. But they do have that right.
That's a great answer. There's one question about answers themselves, and it's the kind of question I would have been able to answer maybe a couple years ago, but I think you're perfectly placed for it, which is, if you go into housing court, you file an answer for a non-payment, what is the usual turnaround for a court date? It used to be like 2 weeks or like 3 weeks. Once you file that answer, they give you the court date. What are you seeing? Kind of how long before they get a court date?
It really depends on the court. When I can only use my example in Queens a few months ago, for people who live in small housing. So if they're in like a 2-family house or something like that, it's usually a very quick turnaround, about 3 weeks. For other people, I think it was about 2 months is what I was seeing. There's a special part in a lot of, I think in every court now, for people who live in small buildings, and those cases move much quicker. The people who are living in larger buildings, those cases are fairly delayed right now, at least in my experience.
Someone asked a question about a notice to cease, and I think then they put notice to cure, which we talked a little bit about here. But what if you want to speak to like notice to quit, notice to cure, those types of cases?
Yeah, absolutely. So if a person is going to be evicted based on a breach of their lease, a breach of lease provision, they're going to first be served with something called a notice to cure. So basically, if a person lives in a rent stabilized building and they're landlord is trying to evict them because of some behavior, they're going to get a notice to cure. And I'll just use an example, like a pet example. So if a person has a pet and they're not allowed to have a pet under their lease, they will receive a 10-day notice to cure stating, I know that you have this pet. You have 10 days to cure it and show me that you've cured that, you've gotten rid of the pet, or I'm going to bring an eviction case. In that situation, they aren't really at risk of eviction yet. Their lease is not been terminated yet. But if they don't cure, if they don't show their landlord that they've gotten rid of their pet in those 10 days, they're going to get a termination notice, and then they'll be brought to court. And that usually is pretty quick. The termination notice will also be about 10 days.
For subtenants, which we get a lot of these, Alyssa and I, because we get a lot of the fun cases that are outside of housing court, pre-litigation. Sometimes subtenants have an agreement with the leaseholder, the person who's supposed to live there, and they pay their rent, and then suddenly they get a notice from the landlord at the end of their lease. What do?
Yeah, these are always really sad cases. If they are being evicted for failure to pay rent, it probably means that their landlord, the tenant of record, has not been paying rent to the owner of the building. And unfortunately, paying to the tenant of record doesn't protect you from a non-payment case from the owner. The same thing is, if they're being evicted because the tenant of record hasn't signed a lease or signed a renewal lease, the subtenant can be evicted, though they're evicted under, different grounds. They probably would have defenses. A lot of these are done improperly. They don't name the person, or they don't name them properly, or they, make up all sorts of allegations about relationships between the different people. So they probably would have defenses in housing court, and they should enforce those defenses. But unfortunately, they probably wouldn't have a right to the apartment unless there was some kind of family relationship and they were living in a rent stabilized building, for instance. So those people, they shouldn't move, but you should warn them that they might have to move eventually.
As a rights counsel attorney yourself, what do you do? Because we saw this actually in the, I think if people have read The City lately, there was all these Harlem cases where these tenants have city FEPS vouchers and they thought their rent was being paid by the city. But as we know, there's a lot of problems, and suddenly they're getting eviction notices. How do you unpack that? If you're a rights counsel attorney, you get a case where city FEPS was cut off a year ago, what's your first step? And how do you kind of go through fixing that?
I think the first step is to figure out why it was cut off. So some people actually are not eligible for city FEPS anymore. And so if it was cut off and they didn't make any attempt to appeal that cutoff, there probably isn't a whole lot to be done. Except, of course, a one-shot deal or something like that, or maybe a different rental subsidy that they're eligible for. People can get cut off of city FEPs because their income goes up, because they don't do a recertification on time, because they've been on city FEPs too long. Usually it expires after 5 years. But if for some reason the checks just weren't getting to the landlord, or there was a mistake on HRA's part, you can usually find that out by requesting records from HRA themselves. Usually you can appeal a denial, especially if they haven't received notice. The appeal deadline is based on when they notified the tenant. So if they never received notice, you can appeal at any time. Those cases, obviously, it's going to take some time to pay the arrears to the landlord. But in my experience, as long as there's somebody around trying to resolve the money and trying to get the voucher back, judges and even landlords' attorneys are pretty understanding about having to go through the bureaucracy. Unfortunately, though, if they really just aren't eligible for city FEPs anymore, they either are going to need to get a one-shot deal if they can pay moving forward, or another rental subsidy.
And if let's say a tenant or tenants went on a rent strike because of uninhabitable housing, what happens in housing court with those cases, and starting maybe from the answer to trial hearing for abatement?
So people should know that rent strikes can be pretty risky, but especially if you're doing it with a big group, maybe you have a little bit more protection, I suppose. Technically, people are supposed to be putting their rent money into an escrow account, which nobody does because no tenant knows how to do that. But if they are withholding their rent because of these problems, repairs conditions in their apartment, they should first keep a record of the repairs conditions, get violations placed by HPD if they haven't already, and take photos. If they get a petition in the mail, one of their defenses or their counterclaims can be warranty of habitability. Basically, you are required to give me a habitable apartment and you are not doing that, right? You are not giving me heat, you're not giving me hot water, I don't have electricity, I have an infestation. They can put that in their answer as a defense. And if they're in this situation, there are practices in I think all legal service providers for big groups of people. So they might be able to get connected to one of the group advocacy units, or at least get information from them. I never want to be like a Debbie Downer, but I do always want to tell tenants that it's very, very rare that a housing court judge is going to give a 100% abatement, which means a 100% discount on the rent. Even for people who are going without heat for long stretches of time, sometimes judges will only give like a 20% abatement, right? So at the end of the housing court case, they are going to have to pay whatever the judge decides is appropriate. And so if they can either be saving their money, putting their money into an escrow account, keeping it safe in some way, that's going to really reduce their risk of eviction.
Excellent. Thank you so much. We have 2 raised hands. I'm not sure if we can unmute. We can try. I can start with Imei Millington Lee. We can try to unmute you. If not, if you could put it in the Q&A. See.
I think she was just unmuted. Imei, if you want to click your mute button.
Or Naya, whichever one of you can unmute faster. I'm gonna go forward and then we'll see if they still want to keep, maybe put that in there. Can the landlord refuse to make repairs if you stop paying rent?
No, the requirement that landlords keep habitable housing is independent from a person's paying rent. Even if a person has never paid rent in a building, in an apartment, technically the landlord still has an obligation to provide them with a safe, habitable home. Now, how easy it is to enforce that right is one thing, but they do have that right. And if they do want to bring it to an HP case, they absolutely should.
if a person, we see this a lot, I think Alyssa, especially working, in Brooklyn and Queens, is private houses are sold or foreclosed, but let's stick with sold because foreclosed gets really complicated. And then, whoever bought the house wants them to leave, or even the original owner who sold it, it's like, you got to leave with no notice. What do you tell those folks when they call you?
So those people have the same rights as anyone else, right? If they have an active lease, a new owner can't cancel a lease that they've already agreed to. For the most part, I don't know how they would do that. And if they've lived there for any period of time, they should receive a termination notice at the end of their lease. If they don't have a lease, then they might get it right away, but they should receive a termination notice at the end of the lease. If they've lived there less than a year, it'll be 30 days, a year to 2 years, it'll be 60, and anything over 2 years, they'll have 90 days notice before they leave. And just like any other tenant, they do not need to leave at the end of the 90 days. They can stay and be evicted. The new owner might do something wrong. Like they might not serve them properly or name them properly. And, people really do have a lot, even if it doesn't seem like they have a right to their home. Moving forward, they usually have a lot of rights in, or a lot of defenses in housing court, and they can enforce those.
So I guess there's some issues where a landlord has issued a lease renewal for a rent stabilized apartment, but it's not on the same terms of the expiring lease. Seems like they changed the terms. And there seems to be a rent order, like an HCR rent order. So landlord's not doing what it needs to do. What should a tenant?
Tenant can know that they can sign that lease if they want to, and it doesn't mess up their rights at all, right? A rent stabilized tenant has the right to a renewal lease on the same terms and conditions. I'm sure that there are some, public policy terms that they can change, but for the most part, they have the right to the same terms and conditions every year. A landlord can try and add terms or change terms, but they have no right to do that. And so if a tenant signs that lease, it's going to be unenforceable. As for an HCR order, they can, if a landlord isn't enforcing it, they should only be paying the rent that DHCR told them to pay. And if for some reason there's another problem, they can bring another complaint with the HCR, which I know will take forever, but they can do that. And there'll be a defense in housing court.
What is our advice generally if things are supposed to be repaired? And they keep saying, like, we have this with mold a lot. They come in, they repair the mold, don't do a good job, and they'd have to just keep coming back and doing the same thing. What would your advice be to a tenant in that case?
These are so hard. What I usually will say is, the first time you go to court, a judge is going to let the landlord basically do whatever they want, right? They're going to say, oh, the landlord's making an attempt to fix this problem. Let's give them the chance and see how it goes. If it's something that you have to go back to court like 2 or 3 times, you should be asking the court to give an order for like a mold expert to go in or a professional mold remediator to go in. I have seen judges do that, especially in NYCHA buildings, at least in Queens, we had mold issues in our NYCHA buildings all the time. But they can, in their order, require a professional mold remediator or really any professional to go in. There's also this wonderful website, if you go to Who Owns What, not HPD's website, but I think it's ANHD or something like that. And you can see every time that there's ever been a violation placed for that issue in your apartment, like on an Excel spreadsheet. And I've seen tenants use that to be able to show that this mold issue or this whatever issue is recurring. So try and show that it's something that's been going on for a long time with HPD violations, and then ask for like a professional like an actual professional, not a super, to fix the problem.
And in that vein, why is it so prevalent that NYCHA has all these issues with mold, but is allowed to kind of continue to not make repairs, not have hot heat and hot water, things like that? Like, why isn't there more done about that?
An excellent question. NYCHA will probably say it's because they don't have funding, which I suppose is probably a little bit true, right? If they don't have enough money to be fixing these problems, they really do need more funding. But funding is not a reason not to provide people with safe, habitable homes, right? So there is, if you're coming up with the same issues all the time, especially if it's related to water damage or mold, which it often is, there is basically a person in charge of that, the mold omnis person, who you can contact. That person was put in place to deal with exactly this problem. You can also escalate the issue to NYCHA attorneys if the management company isn't fixing the problem. Once you're in housing court with NYCHA, you're usually talking to a NYCHA attorney. And at least in my experience, I know Simone has great contacts, but in my experience, the attorneys know that they're required to fix things. So they'll get more involved. But it is really hard.
And I know you mentioned this, but maybe we can there's a question in the chat. How can you get a tenant HPD violation in place? And I can answer this, Alyssa, if you want to take, water break or anything, but HPD violations in place. So, and I just want to make sure we're understanding, they called 311, notified the owner, took pictures, working on mailing landlord a certified letter. Definitely do that with the doctor's letter. And I had put this in the Q&A, but not in the chat. We have a sample doctor's letter that we send out to Harmony with this training, which is always just good to have. In this case, I think what you would do is once you do send out that certified letter and give the landlord a little bit of time to make those repairs, you want to bring it to HP court, which is what Alyssa was referring to. And we're going to have a very in-depth training on this May 16th, and I hope everybody can make it for that. Let's see, other questions. There was a lot of questions just generally about how to answer this specific issue. So if a tenant had HRA payments, how do they answer if they're not getting their HRA payments? Should we tell people where to put that in the answer, or just do a general denial?
I think just based on my experience, and it could be different in different courts. When there's a tenant who's in court, the judge is far more likely, or the court attorney, really, it's not going to be a judge, is far more likely to just talk to the tenant and figure out what's going on, as opposed to looking at what is in their answer as a defense, right? It's very unlikely that they're going to be going to trial in a non-payment case. And as they're trying to negotiate a settlement, a court attorney isn't going to care if you do the answer properly. If you want to, there is a section for other in the answer, and you can say, I have FEPs, they're supposed to be paying my rent every month. It's not my fault if they're not, right? They need to figure it out. So, technically the tenant is responsible for making sure that the FEPs is getting to the landlord, but you can just put that defense in I've already paid rent or in other.
I have two questions that I know of that I want to ask you. One was, what about, we see this a lot, tenants who have vouchers and they're applying all over the place and they keep getting denied. A resource that I'm going to put in the chat is Unlock NYC, which helps people understand source of income discrimination. But can you just say a little bit about that?
Yeah, absolutely. This is something we see all the time. Every week, people who have these fantastic vouchers that can actually, they increased the vouchers to a lot recently. It's basically like a market rate apartment that you can rent with a voucher now. And people are still having such a difficult time using them. And if they are applying for places and, getting to a showing or talking to the landlord and then being denied as soon as they are saying, hey, I have this voucher, you don't have to check my credit, you don't have to ask for income information, it's going to be paid. That is probably a source of income discrimination. It's illegal in New York City. And in theory, there are government agencies that are set up to be able to help them. The Attorney General's office has a source of income discrimination complaint form, Tish James. And there's also, with the New York City Commission on Human Rights, a similar complaint form. I think both are available online, and both you can call. They used to be really good. but I know that they had huge staffing issues over COVID. I think everyone in the source of income discrimination group left. So hopefully they're building that back up. But in theory, the AG's office or the New York City Commission on Human Rights should be able to help people. It can also just help that tenants know their rights so that they can say, hey, I have an attorney on speed dial and they're going to sue you. Maybe that'll work. I don't know.
Absolutely. I know we've sent our share of source of income discrimination cases when, mostly when we're dealing with hospitals where they're trying to discharge a patient, but the apartment is not habitable. So we got them a voucher through APS and nobody's taking the voucher, right? So in those cases, we have been very successful in saying you're committing source of income discrimination. And just the biggest one they do, which I just wanted to note, was credit. They love to say credit, which is kind of a dog whistle, because the credit that counts is the city's credit, right? So if you have a City Feds voucher, it doesn't matter what my credit is if I have a City Feds voucher. It matters what New York City's credit is. So that's usually our back and forth with landlords, and then they eventually give it when you threaten to sue them. What I know that there's a lot of issues right now with staffing. You had stated with home base, and we have a lot of wonderful home base workers here working very hard to try to help with this crisis in the city. And there's also staffing with HRA that's an issue. And there was a very long question in the chat about how frustrating a one-shot deal was. They're helping a community member with a one-shot deal and it's taking forever and they feel like it's just going to be denied. What was that like for you when you were mostly in housing court every day and now as well?
Yeah, I mean, it's so difficult. I know everyone is trying their best, and you can tell when you talk to people at HRA or home base that everyone is just completely overwhelmed. So I totally get that. I will say that I think it's a lot easier for a housing attorney to get their client a one-shot deal than it is for a tenant to do it on their own. It's not fair, but tenant attorneys do have like a special advocates email that we can use. I'm not sure if there's something similar for other types of advocates. But in my experience, I would say that if they aren't getting a response within 30 days, they are required to respond within 30 days, and a tenant can request a fair hearing. I think that that's probably the fastest you're gonna be able to get the application processed. After 30 days, it's deemed a denial, and they have to give a reason for the denial. And in my experience, if you request a fair hearing, they're just going to approve it rather than go through the process of doing a fair hearing. So it stinks. 30 days is a very long time to wait. It's not the way it's supposed to be done, but that might just be your best bet.
Thank you. I'm going to go back to eviction prevention kind of tactics and the world of housing court. The big one was a great question, which was, we put in this slide that you want to request more time. When we say order to show cause or OSC, it means requesting more time. Is when you go in to do an OSC, is it guaranteed that you will get more time?
That's a great question. No, and I should have said this. So the process for requesting more time, it'll look like this. So a client or a tenant will, most commonly, a tenant will sign a stipulation and they'll say, I'll pay $5,000 by March 1st, or I'll leave. A lot of the time there will be a warrant in that stipulation because they didn't have an attorney to tell them that they shouldn't do that. And so the warrant will issue the next day. The warrant will issue March 2nd. They've been waiting for HRA forever. They haven't been able to pay the money. They are going to get evicted. They'll go to housing court and they'll file an order to show cause requesting more time. They'll explain that they've been trying to deal with HRA and it's going so slowly. And they'll wait around for a while for a judge to sign it. But a judge will almost always sign it. Unless you've done like a lot of orders to show cause, judges will very often just sign it and it's fine, and they'll give you a new court date. That time between when you file it and get a new court date, that's not like time that a judge is giving you. It's just, that's when we're going to be able to deal with this order to show cause. Those will almost always be signed. When they go on that next court date, the landlord's attorney is probably going to oppose it, unless it really does look like they're going to get the money. And the tenant is going to have to show why they should get more time. And the judge isn't just going to say, unlimited time. They're not going to say you get a year to figure out the HRA thing. They'll say, hey, go to HRA, you have 2 weeks. If still you can't get it done in 2 weeks, you need to come back and do the whole thing over again. Now, I have done so many OSCs. You can get like 6 or 7 signed. It's possible. But every time that you get one signed, it's less and less likely. So people should do it. People should do it early, get the time that they need, but know that once they're getting onto their 3rd, 4th OSC, they might not even get it signed, and they could get evicted pretty quickly. I hope that answered the question.
That's an excellent answer. And I think untangling all the, little things that we refer to as housing attorneys, I think is difficult. So people, there's still time for questions. So if you have questions about that specifically, please put them in the Q&A, because we have Alyssa here. And so there was a great question on, like, let's say you have someone who's elderly or disabled in a nursing home and they want to discharge them and they're at risk of eviction. What is our advice in those cases?
That's a great question. I mean, I think it probably happens pretty frequently. In theory, they should be able to get a GAL, a guardian ad litem, to help through the eviction process. If they're, in a nursing home or inpatient and currently getting evicted, right? Because obviously they cannot be going to court. So usually, as long as the court is aware of the situation, they are obligated to appoint a guardian ad litem who is there, who should be helping to navigate the process. If they're behind on rent, the GAL is supposed, and I'm sure they do a great job, is supposed to be helping them get a voucher, a one-shot deal, something like that. If they're being evicted for another reason, like an end of lease holdover, the GAL should be making attempts to try and help them relocate or ask for more time. It really depends on why they're being evicted, if they're going to be able to get discharged easily, I suppose, before they're evicted. But if it's just about money, the GAL should be there to help fix it. You can always make a referral to APS as well. And usually in those cases, judges will require, before an eviction takes place, that APS be notified of the situation. But hopefully the GAL will be on top of it enough to be sorting the situation out. The GAL can also hire an attorney. And when I say hire, I mean get a free attorney and
retain, yeah,
working together. You don't have to pay for it.
Someone asked a little about screen G. I'm going to put the info for screen G in the chat. I'm also going to ask the person who asked about disability being granted, if you could put that question in the Q&A and maybe expand on it, because it's a little confusing what you're asking. Is the question, if a person is on disability, do they have to go to court for a housing court case? So if you could put that in the Q&A and just clarify, but if you want to just talk a little about screen injury, because that also has to do with disabilities, that'd be great.
Yeah, screen injury are fantastic programs. They're so great for people who are disabled or who are over, oh man, is it 55 or 60?
62.
62. Okay. For people who are over a certain age, probably 62, or who are disabled, usually what they're looking for is SSI or SSD, but you don't necessarily need that. But if a person is disabled over a certain age, they can get, and if they live in a regulated building, they can apply for this thing called SCREE or DREE. SCREE is for elders, DREE is for people who have disabilities. It freezes their rent at the current amount, and any lawful increases will be paid basically through tax breaks to the landlord. It's administered by the Department of Finance. Unfortunately, it only applies, like I said, in regulated buildings, but it's a really great program for helping keep people in their homes long-term. I had somebody who has been on DREE and then SCREE for like 20 years, and her rent was super, super low. And she'll never have to move out of that apartment as long as she continues to pay her fairly small share. So it's a really great program. Highly recommend people applying. Very simple application.
Great. I didn't see anything else in the Q&A. You've answered so many great questions, Alyssa. I'm not sure. There was a heat seek. I will put that in the chat right now, but a lot of this will be sent out with the slides and everything. So if anybody has any more questions and wants to unmute or put them in the Q&A, please do so. Don't see anything else. So thank you so much, Alyssa. If there's anything else you wanted to say before going, you did so much. You explained so much, and thank you so much for your time.
On behalf of the consortium, we would like to thank you so much, Alyssa and Simone, for leading this training and answering so many questions. I think there might be one or two more.
I do see it. Yeah.
Yes, but to quickly put a plug in for our upcoming events, we have a webinar tomorrow on CORE, which is community-oriented recovery and empowerment. Next week, we have a training on adult care facilities. On March 2nd, we have an Ask a Lawyer session all about homeless rights. And then on March 13th, we have a Flipping the Script event, a teach-in for healthcare workers on homelessness and aging. I'll put all these event links in the chat, and then we could let Alyssa and Simone answer these final questions.
It's just one. Where can you find an attorney to file for a one-shot deal?
Oh, I wish I could tell you, but unfortunately, I don't think that there are any attorneys in New York. I mean, free attorneys is what I mean, in New York that will do a one-shot deal if they're not also connected to the underlying housing court case. People can apply for a one-shot deal just with a rent demand. They don't need to wait for a petition. If they're doing that, they're probably going to do it on their own. It's not a bad idea. If they're in housing court and they think that they're going to need help navigating that process, they should really ask to be connected to counsel. Unfortunately, they're probably not going to be able to get an attorney any other way.
Thank you. And if there are specific discriminatory reasons for possibly denying that, there are, some public benefits attorneys who do assist with fair hearings, but Alyssa's point about finding a lawyer to help with that is very difficult. And sometimes our advice is after 30 to 60 days, if you've had a denied one-shot deal and nothing's happening, reapply for the one-shot deal. Let's just do this again, which is not easy. And we're not making light of how difficult it is, but sometimes that is the best advice while
Sometimes
you
it's
wait.
easier than the alternative.
Absolutely. Because by that time you maybe have all the things that or you have a different person, you have more people working in that office, etc. So,
if they're just not getting the interview, and I feel like this is so common, if they're just not getting the interview, there's a callback number that they can use.
yeah,
That might be the fastest way to do it. I know that it's still waiting on hold and, it's a whole process. If that's the only problem, they probably don't need an attorney and they can just schedule the interview. If the problem is like, they're not getting a response after they've done the interview, then I think what Simone said, either do a fair hearing or just reapply.
okay. Now we really don't have any more questions, but I promise no. Thank you so much, Alyssa.
Yeah, thank you, Alyssa.
Thank you all.
We'll send recordings and slides to everyone later this week. Again, thank you so much. I hope everyone has a nice day. Take care, everyone.